here to talk about this. And then she went on to say for my next hearing in front of the next judge in May that she is going to subpoena my DHS social worker who took my kids. She's going to subpoena her to testify in front of the other judge. I said, wait a minute. This is the social worker who lied and took, and you're going to subpoena her, and I'm in federal court against her, but you're going to subpoena her when they're not involved in my case anymore. So here we go. DHS.
So would you say that our technique of docket monitoring and what is happening in our courts, would you say that Judge Diane Thompson in the Court of Common Pleas Family Court Division, her primary role is nothing more to act as a factory worker to push your children further into the fast-track, sealed, closed dockets of PA Superior Court, DHS contractors, and the abuse, the prolonged abuse, so that everybody gets paid? Because Methodist kinship was in there. Remember, that's what is a contractor got paid. So, and what is isn't the impact of prolonged abuse and sustained injuries being suffered by your children, particularly mental cruelty being inflicted upon your daughter?
Yes.
Right, by their father, the abuser.
Right.
So Judge Diane Thompson weighed in and gave us proof positive that she's not a complacent accessory. She is a willful, complicit accessory to the prolonged abuse of children for the sake of DHS contractors' profit, okay? And that's what the felony charges should be. That's what the federal court charges should be in any class actions that come against solely Diane Thompson. That's what we're learning, that we're gonna break away from filing with all these group defendants where they can just abbreviate it, and once they get the judge, when they abuse the immunity language in the 1983 Civil Rights Act and call our answers amended complaints like they did to you. Did you see your docket? Did you get anything in the mail yet? What happened on the 26th? Your USDC?
Some case certified. I asked them to redeliver it from Mary Ann Taylor.
Well, let me tell you what happened. Let me tell you what they did. Remember when you filed the answer, Judge Alice Dubow got a taxpayer paid Michael Daly from Supreme Court Administrative Offices. They have access to attorney representation that we pay for as taxpayers when we can't get attorneys, right? To file a motion to dismiss based on the fact that Judge Alice Dubow has immunity in the 1983 Civil Rights Act, right? You filed an answer on the 4th, January 4th, that said, no, she doesn't because there's no immunity language, and Alice Dubow has forfeited immunity in the 1983 Civil Rights Act because there's nothing in that act that says it's all right for you to willfully know that you're prolonging the abuse of children and you're participating in corrupt relationships formed in your courtroom H by violating your very own standing rules order for courtroom H. You did not check out the credibility and integrity of DHS's investigation and data. You did not check out whether or not the attorneys were acting on the best interest of parties' behalf, and you were negligent at best. Now that you come back and you try to defend your negligence, now we know you're willful. So you filed that as an answer to their motion. You answered the motion. What is due now? What's due now on the scorecard? If you monitor the docket, the federal court judge can render a decision based on their motion, Michael Daly's motion to dismiss, right? The Supreme Representative Alice Dubow motion to dismiss on immunity, and your answer saying no, she doesn't have immunity, she has criminal liability. The federal court judge, by simply by delaying, ignoring, right, allows them to come back up and say, we want to motion to dismiss the amended complaint. The court clerk who has control over how your answer was docketed entered your answer as an amended complaint. So Michael Daly, acting unethically, sought to take advantage of that and say, we want to dismiss the amended complaint, which buys them time. They don't even have to address the first complaint. They just erase that through the docket monitoring. Now, the court just drags its feet, U.S. District Court, the federal court says, well, we just won't answer. Now, what happened on the 26th is, well, you filed on the 19th a motion for the court to correct the error that erroneously caused plaintiff's answer.
We had more witnesses. You there?
Yeah, are you there? Plaintiff to erroneously, so you filed a motion saying The court has erroneously filed my answer, calling it an amended complaint, and the docket says that's how it is. Right? It is not an amended complaint. Correct the error, and you gave further discernment of the corrupt relationship and the egregious behaviors of the child advocate, Carlin Talib Safir, and the egregious behaviors of a attorney representation that was conflict of interest, that is no longer your attorney. So instead of them correcting the errors, the U.S. District Court judge and the clerk, they just dragged us and don't do anything. Let it lay there since the 20th. There was no activity since January 20th. That brought while they were robbing you of your oral argument in PA Superior Court because Alice Spector-Bowes' wealthy retired judge mother was appointed in February in a news release in an advisory capacity, so that a duly won oral argument through duly lawful filings that was listed could be usurped and pulled out from under you. While they were doing that, the two courts acted in synergy together to buy DHS time. On the 26th, DHS's attorney came in, right, for Anne-Marie and Ambrose, Karen Reynolds, and Carla N. Gardner, and said, we want to join Alice Spector-Bowes' motion to dismiss amended complaint. The amended complaint is non-existent. So
there is an amended complaint.
The docket manipulation is this.
Right.
This is a docket manipulation. The U.S. District Court left it at an amended complaint, left your answer to read an amended complaint. It completely ignored your motion to correct the errors that called for an amended complaint, and it prejudicially favored Department of Human Services, Anne-Marie defendants, official corruption, fraud, civil rights defendants, Anne-Marie Ambrose, Karen R. Reynolds, and Carla N. Gardner by buying them time for DHS legal department attorneys to put in a churn-style template joinder to join a non-existent amended complaint. It's not there. It's an error. So that's how they're going to dupe you out of your due process. They're going to jerk you out of your due process in federal court, and this is disclosed through docket monitoring. No, we can't force them to do anything. No, it's not safe to complain what a federal court does, because they'll send the U.S. Marshals to your house like they did mine and threaten you with arrest. However, we can't, there's nothing stopping us so far yet from publicly posting it. Hopefully they won't lock us up for publishing truth in public record. We can post what happens in the docket activity through docket monitoring, and any eyeball, you don't have to be a rocket scientist looking at it. If we get help from the U.S. Department of Justice or UN High Commission for Human Rights, or one of our Supreme Court Rules and Procedures Committee, or our Supreme Court eventually looks at it, or anybody, the community will be able to connect the relationships and see this is a pattern of conduct through docket control, how they are duping us out of our constitutional state and U.S. constitutional rights to due process.